What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta. I'm not going to do a long introduction. This is a correction. I am issuing a correction in the the Mars Argo versus Sinclair and Titanic. Titanic, Sinclair, and Poppy lawsuit. So last night I recorded, or 2 nights ago, I don't even know what day it is anymore. I recorded a video about this lawsuit, and I made an error. I am not a California attorney, and I did some research on this, but my research was not quite correct, and so I found out today that I was incorrect on this, and I wanted to make sure and update it right away because it does slightly change the analysis that I gave. If you don't know, I was on Fantano's show with Anthony Fantano discussing this, and in that video, I made the correct assessment. This is about the domestic violence issue, and specifically the matter of timeliness. I stated in the previous video that this was definitely outside of the statute of limitations, which I understood to be 2 years for assault and battery in California. However, domestic assault has a different statute of limitations, or they have changed it from the information I have. I'm not quite clear on that, but I'm confident that the domestic violence statute of limitations in California is 3 years, not 2 years. Okay, so there are a couple issues with this. This means that how do I word this? This is the problem. So the domestic violence charges, if they were barred by the statute of limitations because it was 2 years, that means all of these claims are thrown out immediately. However, if it's 3 years, it's potential that they won't be thrown out. And here's why. It's right here, and this is in the under the domestic violence damages section, paragraph 148 specifically. It says, during and after their relationship, defendant Mixter emotionally, physically, and psychologically abused plaintiff, including breaking into Mrs. Sheets' apartment, breaking her possessions, and assaulting Miss Sheets physically. For example, in April 2015, defendant Mixter waited at Miss Sheets' apartment complex gate for her to come home and then punched her in the face once she arrived. Miss Sheets was intimidated by Mr. Mixter and did not make a police report at the time because she was afraid that he would retaliate against her and the abuse would worsen. She feared retribution. All right. If we take this to be true, we don't have a clear answer because this was filed on the 17th of April, 2018. 3 years prior to the 17th of April, 2018 would be the 17th of April, 2015, which means April 15, 2015 is a little vague. If it was April 16th, 2015, it's within this 3-year statute of limitation. Or, let's see. If it was April 18th, 2018, it's within the 3-year statute of limitations. If it happened prior to April 17th, 2018, it's outside of the statute of limitations and has to be thrown out. Because this is the last act that they allege occurred. Okay? So, it really depends on what date specifically this happens. They haven't alleged that date with particularity. That's a problem for this complaint. If they don't give a specific date so close to the statute of limitations, the judge might not uphold it. And what Mixter's attorneys will likely do for this is simply say, one, it never happened. They'll say there's no police report, there's no documented evidence of this. All we have is one person's word that's 3+ years old, right? How do we know that this is a thing? How can my client possibly defend against this? 2, the other thing they could, they will say is that even if this did happen, it's outside the statute of limitations because this happened prior to April 17th, 2015. They'll simply say this event in which he did not strike her at all, but was waiting outside the gate, for example, and maybe she felt intimidated and there was a misinterpretation of what happened. This event happened on April 5th, 2015, or something like that. Outside the statute of limitations, no good. Let me cover a couple more things. This is supposed to be a short video and I'm not good at them. But there are two things that happens. If the judge finds, or the finder of fact or whoever finds that this was within the statute of limitations, this would be a judge because it's a legal question. So if they find that this happened within the statute of limitations, then all of the domestic abuse events are potentially considered in this claim. Even though those events were unquestionably outside the statute of limitations, the California courts have implemented something called chaining, where they chain together a pattern of behavior related pretty specifically to domestic violence and a couple other crimes. So they'll say that the last act is what tolls the statute of limitations, and every act before that, no matter how far back it goes, so long as it's consistently within the pattern of behavior, counts as within the statute of limitations. So it's really, really important for Mars Argo to assert that this April 2015 occurrence happened after April 17th and is within that 3-year statute. Okay, so that's really important to the domestic violence claim. The other part of the domestic violence claim is that is complicating thing, or that could complicate things, is that, and I'm not 100% familiar how the statute is worded in California. Okay, again, I'm not a California attorney, but this would probably be an argument either way, no matter how the statute is worded. But it says that their relationship ended in 2014. They presumably stopped living together between these two events, because it does say he waited at Sheets' apartment complex. The domestic violence statutes are pretty specific. You have to be either in a close personal relationship with someone or living with someone. They may consider a former relationship as inclusive in domestic violence, especially with the allegation of a pattern of behavior. But again, we're looking at the perspective of what Sinclair's attorneys would say. Sinclair's attorneys would say, as a potential argument, along with this is outside the statute of limitations, this never happened, whatever, that this has nothing to do with their domestic relationship at all and cannot be considered a domestic violence issue. Therefore, it's a regular assault and battery type issue, and again, time barred by the statute of limitations. It should not fall within a pattern of any sort of presumed or accused pattern of abusive behavior because they were no longer dating at the time, they weren't living together, can't be domestic violence at that point. That's not necessarily a winning argument, but it is the argument they should be making if they're acting in the interest of their clients, right? If they're combating this. So thank you very much, guys, for watching the first video, the full analysis video. Check out Fantano's video if you haven't yet, where I talk a little bit about the situation with him in a little bit different perspective than just my legal analysis. We have a little more conversation like normal people, although there is legal analysis in there. But much thanks to him for letting me on the show. And if you're here watching because of that, make sure and thank him for having me on the show. If you're so inclined, hopefully you find my content entertaining as well. If you do, hit like and subscribe, leave comments, argue with me. It's great. I love interacting with people in the comments and on various social media. So, yeah, hopefully this, I didn't intend to mislead anyone in the first video. I had just simply not gotten the research 100% correct, and it's outside of my practice area being in California, whereas I'm in Minnesota, and the laws are a little different. So hopefully this update helps. Thank you so much for watching. Talk to you later.